In the complex world of South Africa's road accident fund, there is a deep and damaging confusion. It's a crisis that operates quietly, but its effects are devastating. The central question is simple. When a person is injured on our roads, who gets to decide if the accident actually caused the injury? Is it the doctor who first assesses them? Is it the special appeal tribunal set up by the RAF? Or is it our courts of law? The fact that there is any ambiguity in the answer is a profound failure of our medico-legal ecosystem. When statutory bodies overstep their power, they don't just break the law. They break the promise of justice for the most vulnerable members of our society. This confusion creates delays, increases costs, and undermines the very reason the Road Accident Fund exists. As a catalyst for impactful change, I believe we cannot let this stand. We must dissect this challenge with strategic precision, using a framework built on 3 pillars: integrity, innovation, and impact. Integrity means we return to the fundamental rules. We respect the clear boundaries that the law sets for every role player in this system. Innovation means we design smarter, clearer processes that remove this confusion once and for all. And impact, the most important pillar, is about ensuring that this system delivers what it promises: fair, timely, and just outcomes for every single claimant. This is my definitive guide to solving the causation conundrum and to building an RAF system that truly serves its purpose. Let's first break down the core of the conflict. When you claim for general damages from the RAF, your injury must be classified as serious. A medical practitioner assesses this, usually by filling out an RAF4 form. If the Road Accident Fund disagrees with the doctor's assessment, the dispute goes to the Road Accident Fund Appeal Tribunal, which is a panel of medical experts. Their job is to resolve the disagreement over the seriousness of the injury. But the conflict explodes when the question of causation gets mixed in. The tribunal starts asking not just, is the injury serious, but was this injury even caused by the accident in the first place? This might seem like a logical question, but it's one the tribunal has no legal power to answer. A finding on causation is a fundamental part of determining legal liability. It is a decision reserved for the High Court. When the tribunal makes a ruling on causation, it is usurping the power of the judiciary. This critical error has been addressed directly by the Supreme Court of Appeal, which has now given us a clear map to follow. To understand why the tribunal is so clearly in the wrong, we have to look at the bedrock of our country's governance, the principle of legality. It's a simple but powerful rule that flows from our Constitution. It means that a public body like the tribunal can only do what the law explicitly allows it to do. It has no inherent powers. It is a creature of statute, and its authority is strictly limited by the regulations that created it. Any action it takes outside of those powers is legally invalid. The law gives the tribunal a very narrow, very technical job: decide if an injury is serious. It says nothing about deciding causation. For the tribunal to assume that power is a classic case of acting ultra vires or beyond its powers. Furthermore, we must understand the crucial difference between factual causation and legal causation. Factual causation is a medical and scientific question. But for the accident, would this person have this injury? A doctor is the perfect person to provide an expert opinion on this. They can look at the evidence and say, in my medical opinion, this injury was caused by trauma, not by a pre-existing condition. But legal causation is a question for a court. It asks if it's fair and just to hold the fund legally responsible. That is a policy decision, a legal decision, not a medical one. The tribunal has been conflating a medical opinion on factual cause with a final legal determination of liability. This brings us to the proper roles within the RAF framework. The Supreme Court of Appeal, in the landmark cases of Gowes and Coughlin, has given us the blueprint for process innovation and integrity. The role of the initial assessing doctor is clear. They are professionally required to give an opinion on causation. It is impossible to assess an injury without understanding its origin. This opinion forms the essential medical foundation for the entire claim and gives the fund the evidence it needs to make its own decisions. But it remains an opinion. The role of the tribunal is equally clear. It has no role whatsoever in determining causation. The Coughlin case is a cautionary tale of what happens when this line is crossed. The tribunal decided an injury wasn't serious because it believed the claimant's psychological condition was caused by substance abuse, not the accident. The Supreme Court of Appeal struck this down, stating plainly that the tribunal had exceeded its powers by making findings on causality, a matter reserved for the courts. This isn't a technicality. This is about a real person whose path to justice was blocked by a body acting outside the law. So, what is the definitive opinion? What is the path forward to create real systemic impact? First, the medical practitioner provides an expert opinion on factual causation as an essential part of their assessment. Second, the Road Accident Fund Appeal Tribunal has absolutely no jurisdiction to rule on causation. Its job is to rule on seriousness, and seriousness alone. Any mention of causation in its ruling is a legal error. Finally, our courts, and only our courts, remain the ultimate arbiters of legal causation and liability. This legal clarity must now become our blueprint for action. For legal practitioners, this means you must frame your arguments before the tribunal with precision. Focus only on seriousness. If the tribunal oversteps, you must be ready to take its decision on review. For medical experts, you must structure your reports clearly, framing your conclusions on causation as your expert medical opinion. And for the Road Accident Fund and the tribunal itself, they must adopt these principles as binding policy. They must train their members and create clear directives that the tribunal's mandate is limited to seriousness. By embracing this clear division of labor, we harness the expertise of everyone in the system correctly. We let doctors be doctors, lawyers be lawyers, and judges be judges. This is how we restore integrity. This is how we innovate our process. And this is how we deliver a positive, meaningful impact on the lives of those who depend on this system.